The spending clause doesn't actually use the word spend, as you may have noticed before. It tells us that Congress shall have the power to provide for the common defense and general welfare of the United States. And Article 1, Section 8, Clause 1 also gives Congress the power to tax, but it was a limited form of taxation. Now, at the same time that Congress was given its enumerated powers, we also got the 10th Amendment, which is at the heart of the debate that we're talking about now, because ever since the Supreme Court has taken on the task of interpreting the 10th Amendment, which tells us that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Well, first of all, that last phrase is just read out of the 10th Amendment, so don't worry about that portion of the show. But beyond that, there's long been a debate as to whether the Supreme Court should intervene in the relationship, that tense relationship that's set up between Congress and the states. Congress is given certain enumerated powers. Those enumerated powers are enhanced by the Necessary and Proper Clause, which tells us that Congress has the ability to act beyond those enumerated powers, at least in certain circumstances. And then the 10th Amendment tells us that if it hasn't been given to Congress, it remains with the states. Sometimes the Supreme Court has said, this is but a truism. It's just a reminder that there's this relationship between Congress and the states retain what hasn't been given to Congress. Other Supreme Courts, depending on the sort of tenor of the court, if you will, and the justice leading the court, have told us that it's the court's job to police that line between Congress and the states. We have been living through two Supreme Courts now, the Rehnquist Court and the Roberts Court, are courts that have told us that it is the Supreme Court's job to police that line. And that's part of the debate here, writ large, in the ACA litigation. Whose job is it to make these decisions? Where does the power lie? And is it the job of the Supreme Court to police this line? If so, what does that mean? I would posit what it means is that the court is actually aggrandizing its own role in what might otherwise be legislative or elective branch questions. Finally, what I'd like to mention to you is a provision in the Constitution that doesn't get discussed very much, but that is important for understanding the history of the spending power. The 16th Amendment made it so that Congress had the power to have an income tax. And so it wasn't until the 16th Amendment was passed in 1913 that Congress actually had enough money to do much with its spending power. And so we don't even really have any spending clause litigation until 1936 when Butler is decided. So there's no deep history here the way that there is with certain other provisions in the Constitution. This is all modern history, at least in constitutional terms. The first Congress, the framers of the Constitution, they couldn't have contemplated the things that we're talking about now. The most powerful weapon was a musket, which I could dodge in my sleep, okay? So when we think about what the framers would have thought about these debates, the truth is they wouldn't have thought much about the spending power because there wasn't much to say about it at the time the Constitution was written. However, it is important to remember that in part the Constitution was a response to the Articles of Confederation, which did not create a strong enough centralized government. And so Congress did need power to spend so that it was not at the mercy of the states in creating a strong enough centralized national government. So there are reasons to understand that the spending power is an important standalone power for Congress. Now, another question that I think often comes up in this context and hasn't been addressed yet today is whether there's a constitutional right to health care. Now, of course, the answer to that is no, unless you're a prisoner, in which case the 8th Amendment tells us that that would be cruel and unusual punishment to withhold health care from you. So for the rest of the country, there is no right to health care. Well, okay, so think again about context. Why is that so? This painting by Eakins, which is a famous painting about the operative theaters in the late 1800s, postdates the Constitution by 100 years and already looks barbaric to us. So if you think about what was happening at the time the Constitution was written, what we're really thinking about is, oh, bloodletting, leeches? I don't think I want to write to that, thank you. And the framers didn't even think about it. So healthcare is not a right that's written into the Constitution. Nevertheless, Congress has responded to this deficit in a number of ways. And so that brings us to thinking about the nature of statutory rights. which are often created in response to deficits in the Constitution and the constitutional structure. And so as you may be aware, this is President Johnson signing Medicare and Medicaid into law in 1965 with President Truman sitting right next to him. He was the first enrollee in Medicare, as you may know. And so the question is, what happens with these statutory rights when Congress attempts to modify them in ways that don't comport with their original design? Do we try to treat this like we treat the Constitution? Do we try to understand that Congress has the ability to modify its own laws? Do we try to understand that time changes all things? Historically, the states were responsible for medical care, welfare, and medical welfare. But over time, that has changed. Incrementally, that has changed. And I would posit to you that the ACA is really the big tipping point in that. Because up until that point, although the federal government had enacted important laws that federalized healthcare to a degree, the ACA really, in many ways, is a federal takeover of healthcare law. Medicaid, as you've heard, is a cooperative federalism program. Now, the interesting thing about cooperative federalism programs is that they invite the states to participate in federal law. So the federal government could have kept Medicaid in its own hands, much like it did with Medicare. And in fact, the reason that Medicare is centralized, as you may be aware, is that the AARP very effectively lobbied for that outcome. The AARP did not want the elderly to be left in the hands of the states and to the whims of their economic woes. And so the AARP very effectively lobbied for Medicare to be centralized with the federal government. And at the time, 30% of the elderly were impoverished. So if you look at Medicare from the perspective of, has it played a role in ending the impoverishment of the elderly due to medical care, the answer is yes, because now only about 9% of the elderly are deemed impoverished. Medicaid invited the states to continue to participate in medical welfare. So the federal government took some power away from the states, but then gave some back. And so the interesting thing about cooperative federalism is that it engages the states. This is one of the reasons that I think the court is too quick to jump in when cooperative federalism is on the line.
In a case from 1981, 30 years ago, the court held that in order for states to be bound by terms and conditions, those terms and conditions have to be specified unambiguously in the beginning. That states have to be aware of what it is that they're buying into. They can't be expected to buy a pig in a poke. And the focus, the right focus in the Arlington case held this, is the perspective of state administrators or state officials who are determining what is expected of them. Can they reasonably be expected to know what is expected of them in some sense of foreseeability? It's important to restrain federal power. Again, as Leah said, that these dollars are not unconditional, they're conditional dollars. And this clear notice rule has both what I call a positive and a negative effect, and both of which were referenced in the Chief Justice Roberts' opinion. First, there's what I call a positive effect to inform state decision-making so that participation in these federal programs is based on a clear understanding of the bitter as well as the sweet. So it's often easy to be put on your rose-colored glasses and say, oh, all this federal money is coming to us, or to use the term that was discussed, boatloads of federal money are coming to us. It's very easy to talk about the sweet, but basically often the conditions from the state's point of view are bitter in the sense that it requires ponying up money or raising taxes or doing something that is a state obligation. And so in order to justify the sweet, the state has to be aware of the bitter so that that factors into the decision-making process. Then there's the negative aspect of this clear notice rule, and it guards against ex post blindsiding, or what the court calls post-acceptance conditions. And this avoids a federal bait-and-switch tactic. So the key issue regarding the Affordable Care Act with respect to clear notice is, when does this notice requirement accrue? Does it accrue when the state initially signs up for the program? And I'll, in a few minutes, talk about this notion of contract formation. But when the states sign up for the program and they form the contract between the federal government and the states and they set up the deal, is that when the notice has to accrue? Or is it enough that the notice accrue when this contract that's already been set up is then modified and there are changes in the terms and conditions? There is a difference in contract law between how courts review the formation of a contract and the modification of a contract. And so this is the leveraging problem. Medicaid is being expanded, but if states didn't choose to accept that expansion, then they lost their pre-existing Medicaid. And so this was certainly a modification, and a substantial modification, of the original Medicaid deal, the Medicaid contract.
We truly were trying to force people to not take government handouts. There was this idea that only if you were blameless for your poverty were you worthy of government assistance. And so that meant pregnant women, children, widows, the elderly, the blind, the disabled. Medicaid built on that structure. And in many ways, it was the caboose to Medicare's train. There wasn't a lot of thought put into Medicaid when it was created. And in fact, again, to go back to that Simpsons analogy, the states asked for more money. Ever since basically the Great Depression, the states had been asking the federal government for money for medical welfare. And they kept asking, and they kept asking, and they kept asking. And over time, the federal government kept giving more and more money to the states. And every time the federal government gave more money in an increment, it decided that it needed to do something more to require the states to actually play by the rules, because the states would take that money and then play games with it. And so Medicaid is in some ways the federal government saying to the states, we're not going to let you play with this money anymore. When we give you money for medical welfare, you have to use it for medical welfare. We're going to create a federal superstructure and you have to comply with it. And if you don't want to comply with it, don't take the money. Go pay for it by yourself. We expand Medicaid to include everyone. This is an important philosophical change in Medicaid, because for most of its existence, Medicaid has not covered more than about 45% of the poor in America. So even though we think of Medicaid as being a safety net, it has been a safety net with gaping holes. And so very early in the conversation about healthcare reform and what would be possible in healthcare reform, when President Obama and members of Congress were discussing what could happen with healthcare reform, it appears to me, from looking at the legislative history, which is itself somewhat convoluted, and that's a different conversation, that Medicaid expansion was always on the table. Now, part of the reason I think Medicaid expansion was always on the table is that every time Congress had expanded Medicaid over the years, the states always agreed. The states have significantly more power in this relationship than they let on in the ACA litigation, because often they are the drivers of the changes in the federal Medicaid program. Often it is the states that are asking for more coverage and receiving it to the tune of more money and some rules to go with that money.
The powers of the federal government are limited and enumerated, not general. So if the federal government, in this case Congress, is up to something, it better have a place in the Constitution where it can stick its finger, not the original Constitution, but you know, copy, and say, this says I'm allowed to do this. And for congressional spending, we're looking at Article 1, Section 8, which empowers Congress to spend money on behalf of the general welfare of the United States. And we know from the way that the Supreme Court has interpreted Article 1, Section 8 over time that this means Congress can authorize the expenditure of public monies for public purposes. One category of public purposes for which it may spend money is to establish cooperative federal-state spending programs. So in other words, Congress can say to the states, we'll make you a grant. We'll give you X amount of money if you do Y and Z things, right? Because, hey, it's the government. It's not going to just hand over a boatload of money and say, do whatever you want to. The big case here that established the contours of the ability of Congress to spend money on these cooperative programs was United States versus Butler back in 1936. Before this case, it wasn't clear whether Congress could spend money in pursuit of the general welfare of the United States, or whether this clause only was tied to other parts of the Constitution, other enumerated powers, and meant that Congress could spend money for the general welfare if the general welfare meant another enumerated power in the Constitution. And the court eventually went with Hamilton's view rather than Madison's. They've been fighting about this for a little bit, and said this is a freestanding provision. So Congress is okay spending money in pursuit of the general welfare. And the Supreme Court has said, interpreting Article 1, Section 8, that strings can be attached to further broad policy objectives of the federal government by conditioning the receipt of federal monies on the compliance of the recipient, in this case the state, with federal statutory and regulatory directives. So Congress can spend for the general welfare. It can have these cooperative state-federal spending programs, but these are the limits on Congress's ability to attach strings to the money it gives to states. The conditions that it's imposing on the grants to states have to be unambiguous. They have to be germane to the federal interests in the program. They can't force states to violate other provisions of the Constitution, and they cannot be coercive. So Medicaid without expansion is a program that has an income requirement and coverage. It provides coverage for selected groups, including pregnant women, families with children, children, blind, elderly, and disabled. Under the expansion plan in the Affordable Care Act, everyone under 65 in a state who had an income below 133% of the federal poverty line would be entitled to coverage with an essential health benefits package that would cover that person's obligation to have health insurance under the individual mandate. The penalty for noncompliance was that the federal government could take away all of a state's Medicaid funding, even if it kept traditional Medicaid. So just make that very clear. We're saying, okay, states, if you don't do Medicaid expansion the way we've outlined it in the Affordable Care Act, we're taking all your Medicaid funds back, not just the funds that you would have gotten for expansion. So the court, when the Affordable Care Act case came before it in 2012, is really looking at two basic questions. Is the expansion a constitutional use of the spending power? And if not, what's the remedy?
The Alaska Packers case involved a shipping vessel, a fishing vessel, and the fishing vessel left shore to go out on catch fish. That was its job, that was the business, and they had sailors on board who'd agreed to a certain wage. They got out into the middle of the ocean or into the fishing waters, and the workers, the sailors said, we're not going to do our job unless you raise our wages considerably. And the owner of the boat was really, dare I say, in a pickle at that point, because the whole purpose of the voyage was to catch fish, and all the expenses that had been accrued would have been for naught. And so they agreed under duress, and then they came back to shore and challenged the validity of that. In the court, the Ninth Circuit said the sailors were free to negotiate on their wages before they left shore. But once they were out in the middle of the ocean, this was a modification of the contract, not the original formation of the contract, and they had too much leverage. And therefore, the court would review and enter into the fairness of that transaction and the substantive fairness of it. And the court concluded that that was just totally a holdup and refused to enforce that contract. In my view, that's really what the Affordable Care Act was with respect to the expanded Medicaid.
As you've heard, 7 justices held separately in NFIB versus Sebelius that the Medicaid expansion was unconstitutionally coercive. No provision of the ACA was struck down. no provision of the Medicaid Act was struck down. Every statute in question in the NFIB versus Sebelius litigation remains the same.
Part of the concern that the courts have expressed is to locate political accountability. And so in that case, is it really the states that would be blowing up Medicaid, or was it the federal government that was saying with these new terms that seem to be attractive, or why is this not attractive, and that the states are blowing it up, or is it the federal government blowing it up? In my view, it was really the federal government that was blowing up the original deal by adding on these extra terms, and yet the states were in the position for having to absorb the political flack that went along with it. And so the idea that there was not coercion is belied by the fact that nearly half of the states have not gone forward with expanding Medicaid.
The court had to understand the importance of the Medicaid expansion from the perspective of states that wanted the expansion, because federalism cut both ways in this litigation. You don't often hear the flip side of this litigation. But the other 26 states that weren't driving the litigation against the ACA, they wanted the Medicaid expansion. They wanted the money that was being offered. And so federalism meant allowing those states to move forward with the expansion if they wanted to. It wasn't just a matter of honoring the states that were fighting the expansion.
But the court held that the states could not be threatened with the loss of the pre-existing Medicaid and allowed this to be seen as a new contract. Formation of a new contract, and the states are free to enter into this new contract or not without the threat of having to lose the pre-existing Medicaid funding. So the court holds that the clear notice rule applied when the states signed up for Medicaid at contract formation, so that the states could not be threatened with the risk of loss to this ongoing program.
You heard before about the South Dakota versus Dole case, the case that gave us a 4-part test for understanding conditions on spending. That case tells us that there are 4 ways to understand how Congress can place conditions on spending. So first, the spending has to be for the general welfare. Second, the conditions themselves have to be clear to the states so they understand what they're getting into. Third, the conditions must be germane to the spending. And fourth, Congress cannot place unconstitutional conditions on spending. Coercion was dicta. Coercion was not actually part of this 4-part test. And coercion had been mentioned in passing, but there had never been a coercion doctrine.
And the Supreme Court held in the NFIB case that the imposition of these new terms on Medicaid and enforcing those terms by threatening the loss of pre-existing Medicaid deprived the states of any real choice. So here the intellectual move was to say the anti-commandeering principle, which under the Commerce Clause had been a formalistic principle, was really the operational meaning of coercion in the context of the spending clause.
Medicaid expansion under the Affordable Care Act is unconstitutional, according to the court, an unconstitutional use of Congress's ability to spend money on cooperative federal-state programs because of the conditions it attached. But the court also said the remedy is to sever, to remove the part of the statute that said the federal government could take away all Medicaid funding from the states that refused to expand. The result is that states were left to choose whether to expand their Medicaid programs and get additional funds, or retain their existing Medicaid program but get no additional funds. It is a gun to the head of the states to tell them, if you don't expand, we take away all your Medicaid funding, that there's no meaningful choice there, that it is coercive. In an opinion written by Justice Scalia, in which 3 other justices joined, says the same thing in essence. It analogizes federal-state cooperative grant agreements to contracts and says just as contracts are voidable if they're coerced, it is coercive here to say we will take away all this money. For context, the average state, their Medicaid subsidy from the federal government was equal to more than 1/5 of that state's budget. So you have here 5 justices saying, we're not sure exactly where the line is between choice and coercion, between a carrot and a stick. But we know that it is somewhere, right? Once you start getting up to 1/5 of a state budget, that's coercive. You have Roberts, Breyer, and Kagan saying the remedy is to sever the penalty for not expanding. In other words, Medicaid expansion could go forward, but it has to be optional. States can't have all of their Medicaid funding yanked if they don't expand, but if they don't expand, they just don't get the money for expansion. That's what happens. And Ginsburg and Sotomayor kind of grudgingly agree, saying we think it's constitutional, but if you're telling us it's not, then the remedy is just to remove this part of it.
This is the first case to strike down spending for the general welfare. It's the first case to articulate a coercion doctrine. And it's the first case to expressly recognize that the 10th Amendment can act as a limit on the spending power. But there are key misunderstandings in this decision. First, the court attributed to Congress a degree of intentionality that I think did not exist. And it's because of this. The court, as Jim said that Congress couldn't force the states to take these post hoc terms, and the fact that it had no backup plan indicates that Congress knew the states would all take the Medicaid expansion. I would characterize it differently, respectfully. I would say that Congress was realistic in understanding that the states had accepted every prior expansion of Medicaid. And so to try to plan for near universal insurance coverage, it was reasonable for Congress to anticipate that the states would accept this expansion as well. It wasn't intended so much to twist their arms as it was an understanding of the history of Medicaid, that every time Congress had expanded in the past, the states were on board. I would also say that there's a misunderstanding in terms of the dynamics between the federal government and the states, because there is a constant negotiation that's going on between the states and the federal government. And we can't think of the states as some kind of black box, as if the states sit over here and they all act in one way, and the federal government sits over here and it acts in another way. Each of the states is driven by different factors and different interests. Those interests were transparent in these negotiations. So think of the Cornhusker solution, right? Initially, Nebraska was going to be the only state that was going to get 100% funding for the Medicaid expansion. But then all the other states said, oh, we want that too. And Congress made it happen. That's state power. The states had negotiating power in the creation of the ACA. The statutory remedy that the court came up with is absurd. And here's why. The court told us that this is new Medicaid. This expansion is to this population that's never been covered by Medicaid. It doesn't look like Medicaid. It's a new program. It doesn't look like Medicaid. It's unduly coercive to attach that new program to the old funding for Medicaid. Where did the court find the remedy for this supposed unconstitutional coercion? In the Medicaid Act. So not Medicaid enough for purposes of coercion, but Medicaid enough for the remedy. Which is it? Again, I posit to you, it is all one program under one statute. It is one Medicaid program.